The way the U.S. treats its prisoners is shameful. Though we as a nation exalt the virtues of fairness, equality, and compassion, our prison system continues to dehumanize, degrade, and abuse the more than 2 million Americans behind bars today, often at terrible costs. On the way home from a party, 16-year-old Khalif Browder was wrongfully arrested for stealing a backpack. Though he maintained his innocence, Khalif was charged with robbery with a bail set at $3,000. A poor kid from the Bronx, Khalif couldn't afford the bail and was sent to Rikers Island jail. Because of New York's congested court system, Khalif stayed in jail for 3 years before his trial. During his time in jail, Khalif endured terrible treatment. He suffered multiple beatings by prison guards, was starved, and spent nearly 2 of his 3 years in jail in solitary confinement. Khalif's charges were eventually dismissed and he was freed, but the resulting trauma from his time behind bars would leave lasting effects on his psyche. Khalif killed himself in 2015, 2 years after his release. His mom would die a year later. Khalif's story brings to light some of the paramount issues with prison conditions today. Physical and verbal abuse from correctional officers to inmates is rampant in the prison system. Additionally, as tragically displayed in Khalif's case, solitary confinement is a frequently used disciplinary tool of prison administrations that can cause a severe and permanent detrimental impact to inmates' mental health. But the problems don't end there. There are myriad areas where prison condition reform is needed, including access to medical and mental health care, basic sanitation and human dignity, protection from sexual assault, freedom to practice a religion, and reasonable communication with the outside world that can be helpful for rehabilitation and preservation of inmates' humanity. Some modest progress has been made in advancing prisoners' rights. For example, in 2003, Congress passed the Prison Rape Elimination Act to reduce sexual assault within prison facilities. Gradually, federal use of private prisons has declined, and the Obama administration ended the practice of placing juvenile prisoners in solitary confinement. But despite these few bright spots, prisoners' rights have regressed broadly over the past 3 decades, primarily due to Clinton-era legislation. In particular, the Prison Litigation Reform Act, or PLRA, was passed in 1996 and has significantly rolled back prisoners' rights to use litigation as a tool to fight for their civil liberties. It is important context that the PLRA was passed 2 years after the infamous Violent Crime Control and Law Enforcement Act of 1994, known popularly as the Crime Bill. The Crime Bill helped catalyze an explosion of the U.S. prison population. Given the dramatic increase in the number of inmates in prison, it is more salient than ever to ensure that they are provided their due rights. The PLRA has been the defining piece of legislation affecting prisoners' rights in the 21st century. It was intended to reduce the amount of litigation arising out of prisons in order to remove the burden on courts. In the 70s and 80s, courts were flooded with cases alleging that prison conditions violated the constitutional rights of inmates. This litigation led to many U.S. prisons being enjoined to make changes that were positive for inmates, but were viewed as a nuisance that tied up valuable judicial resources. The PLRA has several provisions that make it prohibitively hard for prisoners to file suits against prisons. First, there is the exhaustion of administrative remedies provision. This requires inmates to file grievances within prisons and pursue all administrative appeals available to them before they are able to file a suit in a court. This is a highly burdensome multi-step process, and often prisoners lack the guidance or understanding of what the appropriate steps are. The bureaucracy can overwhelm prisoners and lead to suits with strong merits being quashed due to failure to comply with technical requirements. The second key provision is the filing fees provision. Under this, inmates have to pay a monthly fee equal to 20% of their commissary's account's value to file a suit, creating a significant financial impediment for inmates to get into court. This is further exacerbated by a 3 strikes provision. that requires that if an inmate has 3 cases dismissed, for every subsequent case, they must pay the entire filing fee up front to bring a case forth. Given that filing fees are often hundreds of dollars, this creates a significant barrier to justice for prisoners that lack the economic means. Finally, the PLRA has a physical injury requirement provision that bars inmates from filing a lawsuit for mental or emotional injury unless a physical injury can be shown as well, even if constitutional rights are violated. Empirically, there is no doubting how impactful the PLRA has been. From 1995 to 2012, as the U.S. prison population has increased roughly 60%, the amount of claims filed per 1,000 prisoners has declined over 50%. Because of the PLRA, it's much harder for inmates to file a lawsuit than it is for regular citizens. Moreover, it mitigates the role of judiciary as a watchdog over the prison systems and deprives prisoners of a venue in which they can advocate for and defend their civil liberties. So in light of these limitations on prisoners' ability to demand improvement for the conditions of their confinement, who is demanding it? The ACLU National Prison Project is fighting to end cruel conditions and ensure health care and protection from sexual violence. The Prison Policy Institute is working to protect inmates' rights to spend in-person time with family and have affordable phone calls with them as well. An Alabama Equal Justice Initiative investigates abusive and dangerous prison conditions exposing violence, murders, corruption, and rape, challenging the Department of Corrections to reform unconstitutional prison conditions. In the 2018 prison strike, inmates spoke out as well, demanding, among other things, immediate improvements to the conditions of prisons and prison policies that recognize the humanity of imprisoned men and women. So what else can we do? What if we repealed the PLRA? What if we ended solitary confinement practices? What if we extended the right to vote? But is that enough? Will we really listen, really notice the conditions suffered when people are locked away? Or is it that the separation, the locking away, and the ease of our ignorance are the real problems at hand?